This video contains important information about the Corporate Transparency Act. Now, I know your time is valuable, so I am going to quickly try to explain what the Corporate Transparency Act is, how this new law impacts businesses, and what you need to know to comply. Now, the Corporate Transparency Act, sometimes called the CTA, is a new federal anti-corruption law that took effect on January 1st, 2024. Designed to combat money laundering and other financial crimes, the CTA requires most privately owned entities to disclose information about their owners and those who exercise control over these companies. The CTA creates new reporting obligations for most entities formed in the United States. It requires these companies to disclose information to the United States Treasury about their owners and persons who exercise control. And it establishes tight reporting deadlines. I'll have more on that in just a minute. Let's first discuss whether the Corporate Transparency Act affects you and/or your business. In this video, when I use a term like entity or company, I am for the most part talking about corporations and limited liability companies, also known as LLCs. Certain entities are exempt from the CTA. Some examples include publicly traded companies, investment companies, venture capital fund advisors or investment advisors, and pooled investment vehicles. There are highly specific criteria that apply to each one of these definitions. So I urge you to do your own research or reach out to us if you're not sure whether your company is exempt or not. Also exempt are what are called large operating companies. To qualify for this exemption, you must have more than 20 full-time employees in the United States, have an operating presence at a physical office, and report more than $5 million in the prior year. There are other exceptions, but if you don't fall into one of the categories that I just discussed, it's likely the Corporate Transparency Act applies to your company. Assuming the CTA filing requirements apply to your company, what information must be filed? The CTA requires you to provide information about the company's beneficial owners. So let's go through a quick analysis to determine who qualifies as a beneficial owner. Question number one, do you have a 25% or more ownership interest in any company or other type of legal entity? For the purposes of the Corporate Transparency Act, an ownership interest includes shares of stock in a corporation, an LLC membership interest, or any other type of equity, voting rights, profit interest, convertible instruments such as a convertible note, options, or really any other mechanism that establishes ownership. If you own or control any of these things that I've just listed, you're a beneficial owner. There's another way that you can be categorized as a beneficial owner. That brings us to question two. Do you have substantial control over any company or other type of legal entity? For the purposes of the Corporate Transparency Act, you have substantial control if you are a senior officer or general counsel, president, chief financial officer, chief executive officer, chief operating officer, or any other officer who performs a similar function. You also have substantial control if you have the authority to appoint or remove officers or directors, or you make decisions about business finances or structure. If you fall into any of these categories, the Corporate Transparency Act considers you a beneficial owner. Now, certain individuals and entities are exempt from the CTA reporting requirements. So let's talk about who is exempt. First, minor children, but their parent or guardian must report on their behalf. Any employees who are not senior officers or owners, they are exempt from filing. Individuals that hold a future interest through inheritance are exempt from filing. And creditors with no stake in the company other than debt are also exempt. Now, it's important to understand that beneficial ownership applies to direct ownership and indirect ownership. Direct ownership is simple. That is when you own a percentage of a company. Indirect ownership is a little more complicated. One common example is when an individual owns part of a company that owns part or all of another company. Sometimes companies don't have individual owners. They are owned by holding companies or other types of entities. The Corporate Transparency Act reporting obligations flow through. The chain of indirect ownership can be long. For example, if you own 25% or more of a corporation that owns 25% or more of another corporation that owns 25% or more of another corporation that owns 25% or more of another corporation, you get the idea. You are considered a beneficial owner of all four corporations for the purposes of Corporate Transparency Act reporting. So, if your company is exempt from the CTA or you don't qualify as a beneficial owner, good news. The Corporate Transparency Act doesn't apply to you. On the other hand, if, like most US companies, you or your company falls under the CTA's reporting requirements, what do you need to know? Let's start with just a very quick recap of what we've covered already. The Corporate Transparency Act applies to entities formed or registered to do business in the US unless they qualify for an exemption, and the term beneficial owners includes anyone owning 25% or more of a company or exercising substantial control over it. Meeting the CTA's requirements involves understanding and adhering to specific deadlines. Companies formed before January 1st, 2024 must file their initial report by January 1st, 2025. That probably captures most of you watching this video. Companies formed in 2024 must file within 90 days of their formation. So in other words, on the date that we're filming this video, we are already past the filing deadline for many companies formed in early 2024. Companies formed on or after January 1st, 2025 have 30 days after they are formed to file. Failure to comply with the Corporate Transparency Act can result in severe penalties. Civil penalties include up to $500 for each day the violation continues, and criminal penalties can include imprisonment of up to 2 years and or a fine of up to $10,000. Now, there have been some recent developments with this law. Earlier this year, the National Small Business Association filed a case in federal court alleging that the Corporate Transparency Act is unconstitutional because it obligates US citizens and residents to report sensitive personal information in violation of their constitutional rights. An Alabama federal district court agreed. That case is now on appeal before the 11th Circuit. There are also bills pending in both chambers of the United States Congress calling for repeal of this law. Our law firm has been monitoring this case and will continue to do so. But for now, it is our recommendation, which aligns with most experts that I have seen, err on the side of caution and take steps now to comply. It's impossible to know if this law will change or be overturned, but the penalties for non-compliance are serious enough that we believe the safest and smartest step is to submit the required filings. Please don't wait until the last minute. Make a plan now. In summary, the Corporate Transparency Act represents a significant shift toward greater transparency in business operations. By understanding and complying with these new requirements, you can help prevent financial crimes and ensure your business operates within the law. If your business falls within the criteria described in the CTA, I urge you to take compliance seriously. Our law firm is here to help. We are answering questions from and handling CTA filings on behalf of many of our clients. If you have any questions, if you need assistance, or if you would like for us to handle your Corporate Transparency Act compliance filings, please contact us through our website at Clark.Law or email us at info@Clark.Law. Thanks for watching.